Thank you very much for that extremely warm welcome, Angelica. And thank you all for joining me today to talk about something that's kind of fun. The developments in employment law in 2025. Now, at least one of you out there said, Allison, that doesn't sound like a lot of fun, and I hear you, but some of them were genuinely interesting, and I promise I've tried to pick mostly the practical ones and leave the legal theory as far behind as we can. A little bit of theory, mostly practical. So the way we generally look at 2025 reviews like this is what are the issues in 2025 and the developments legally that have been keeping employers up at night? What's been worrying employers? What is worrying employers currently? What should you know? And you'll notice there's a bunch of them that we're going to go over pretty briefly. We can always discuss a little bit more in the Q&A if you've got specific questions. Then, for the last portion of the presentation today, I'm going to do my best to look into my crystal ball and tell you about a couple of things we see heading into 2026 that we think you should be aware of. So let's start with the issues that arose and the developments that arose in 2025 that are keeping our clients up at night. The first one's termination provisions. And somebody out there rightfully is saying, Allison, that's not a new issue, and you're exactly right. Bear with me for about a minute, though. We're going to do a little bit of background on why this is important, just in case anyone feels a little bit uneasy about what exactly this whole issue is, and then we'll talk about the 2025 developments. So, remember that every employee in Ontario has an entitlement to notice upon termination. The minimum notice and severance amounts are set by the Employment Standards Act, which sets a floor for those. For those of you who can't see me for whatever reason, I am doing a lot of hand gesturing at the moment. I just gestured at the floor. That's the Employment Standards Act. Now, if I hand gesture around my head, that's the common law entitlement. And every employee is entitled presumptively to the common law, which is much higher than the floor, unless they have an employment contract which restricts them down to something that is equal to or greater than the Employment Standards Act minimums, but less than the common law. And because there is a big difference in between the two, this can cause significant liability for employers. The problem is that courts in Ontario have been extraordinarily nitpicky in the last little while, and I say that with all due respect to them. Any way, shape, or form they can strike down a termination clause, they have done so. We've particularly seen a swing since 2020 or so to very employee favorable decisions. So any mistake, any problem that they can find with your termination clause invalidates the entire termination provision. And the problem with that is if you have a small flaw in your for-cause termination provision and you fire somebody without cause, despite the fact you're not relying on that for-cause termination provision, the entire termination section is all invalid, for example. So, big issue. The courts won't enforce a termination provision unless it clearly limits the employee's entitlements to something less than common law, and it clearly meets the Employment Standards Act requirements at the very least. So we see a lot of common issues, and coming into 2025, early 2025, some of the big ones were people defining just cause, for example. So a lot of employers want to say, just cause includes theft, or it includes, yelling at your colleagues, or it includes inappropriate behavior. I understand that urge, but because just cause under the Employment Standards Act means that they don't get any notice, there is a very high bar in the Employment Standards Act for what constitutes just cause. And so if you put in your own definition, there is a very, very, very good chance that you could inadvertently violate the Employment Standards Act under that clause, and therefore it's invalid. Sometimes people forget about statutory severance pay. So you get clauses that just say notice, and they forget that the Employment Standards Act has statutory severance pay that you have to address, or they forget that you have to include benefits, for example. There's also this weird one where sometimes people say you'll get your base salary for the statutory notice period, but they forget it's technically all wages. So that might include things like bonuses and other incentives. So coming into 2025, the big issue, one of the big issues, was this case called Dufault, which many of you might be familiar with. This caused a lot of nightmares for a lot of people from February 2024 onwards. Because the court, and this was the Superior Court in Ontario, held that termination language, which said the employer had the sole discretion to terminate an employee's employment at any time, and that's the key phrase, was unenforceable. And the reason for this, and it's a little wild, was that the court said, well, even if you're paying the employee notice, you saying that you could terminate at any time means that you could terminate in violation of the Ontario Human Rights Code, for example. And that would be contrary to the law, and therefore this is unenforceable. Now, the Ontario Court of Appeal heard the Dufault case, they heard an appeal from it, but of course, they didn't actually venture an opinion on this particular issue. So coming into 2025, everyone was a little confused. Is the at any time language causing every contract to be unenforceable? 2025, I am very sorry to say, did not clear this issue up. It made it much worse. So you'll see I've listed two cases here. There was a couple of others, but these are probably the two big ones. The Baker and Van Dolder's Home Team Incorporated case was another Superior Court case, and they followed Dufault. They said, if a termination clause says in any way, shape, or form that you can terminate at any time, that's unenforceable. Now, interesting thing. Same level of court, different judge, different decision, Lee and Wayfair, the court said, oh no, that's fine, that's enforceable. So these are all judgments from the same level of court. They can't overrule each other. And as you can tell, we just have this case law that's a little bit of a mess right now. January 2026, so for the first peek into my crystal ball, January 2026, there's going to be an Ontario Court of Appeal hearing for both of these decisions. So we should get some more certainty in 2026 about this, but one of the big developments in 2025 was definitely confirming if you have at any time language in your termination provisions, I'd strongly recommend removing it at this point in time. Maybe the Ontario Court of Appeal is going to come back in your favor. Maybe in 2026 this will all be resolved and you can follow Lee and be fine. But until then, we just have a mess in the case law, and it's going to depend which judge you get as to what the outcome is. And no one wants that level of uncertainty. Now, the good news out of 2025 with regards to termination provisions is that there was a Court of Appeal decision where they gave a thumbs up to an employment standards minimums clause. If you had talked to me, and some of you have actually talked to me in 2023, 2024, 2022, I would have said, look, the problem is we all know it's theoretically possible to draft a clause that says employees going to get employment standards minimums only. The courts have all said it's possible, but we've never had the Court of Appeal say, yes, this clause is good. 2025, Ontario Court of Appeal looked over the data stealth language, which, in case you're wondering, is the language this firm uses and most firms should be using. That is enforceable language, they said. So that at least is a ray of hope for employers. If you're removing your at any time language, probably should use the data stealth language instead, okay? And so I've given you that case citation. You just want to go straight to that case, find that language, and use it if you can. Maybe get a little bit of legal advice on that because there are some other aspects you want to make sure it's there for, but that's the type of language you want to be using. So that's issue number one. Issue number two, we saw arose a lot in 2025, and that really caused some employer headaches, was the duty to investigate. You will all know that an employer has a duty to investigate allegations of harassment under the Occupational Health and Safety Act. We got some clarification in 2025, though, about the scope of that duty, and it does include even if there's no formal complaint filed, and if the subject of the harassment refuses to participate. It also includes if the offending communication was made privately, and if they don't file a written complaint, but your policy requires a written complaint be filed to start an investigation for harassment. So even if your policy requires it and they don't do it, if you know that there's an incident of possible harassment, you still have to investigate. The case for this was the Metrolinx case, which again, you'll see this is an Ontario Court of Appeal case again from 2025. And this is a long-running case that most of us have been following avidly because of this issue, and we finally got resolution this past year. So what happened in this case was there were five employees who'd participated in a private WhatsApp group chat outside of the workplace on their personal cell phones. And they said lots of not particularly nice things about other employees. And one of the worst was that they shared some very sexist messages about Miss A, alleging that she had performed sexual favors for career advancement. So Miss A finds out about this. She mentions it to her manager, but she declines to file a formal complaint. So nothing happens right then. But what's really interesting is that Metrolinx's HR person finds out about this a couple months later, hears about the WhatsApp group, hears about what's in the messages, and starts an actual investigation. Now, Metrolinx investigates, finds it was harassment, and fires all five employees for cause. The union grieves. And in 2023, what astounded a lot of us was that the arbitrator ordered reinstatement for all of these individuals on the basis of two things. First, that the messages were beyond Metrolinx's authority because they were on personal cell phones, on a private WhatsApp chat outside of the workplace. And secondly, that Metrolinx's policy prevented it from investigating because the policy said you'll only investigate a complaint if the complainant files a written complaint. And remember, Miss A didn't do so in this case. She actually explicitly declined to do so. So we had the divisional court decision come up in 2024 and the Ontario Court of Appeal decision come up this year. So this is now officially the law. And what the divisional court held was that the arbitrator had been unreasonable about that. Even if the subject of harassment is reluctant to report or participate, you must investigate if you hear about an incident of possible harassment. Your internal policies can't limit that. So the fact that your internal policy says, you have to file a written complaint and then we'll start an investigation doesn't mean that you can not investigate if you hear about an incident of possible harassment, but the complainant declines to file a written complaint. And even if the communication takes place on a personal phone, on personal time, on a private platform, it becomes a workplace issue if it makes its way into the workplace. So them having this WhatsApp group chat, if Miss A had never found out about it and no one in the workplace had ever found out about it, might not be a termination-worthy offense and might not be able to be investigated. But if it seeps its way into the workplace, then it does have to be investigated. The Ontario Court of Appeal agreed with the Divisional Court on these counts. And so, as I said, this is definitely firm law in Ontario now. And so you'll want to take notice that that is an expansion of the possible scope of duty to investigate. My third issue from 2025, so I'm saying issue, trend, and development, is one that unfortunately needs no introduction to you. It's the US tariffs. So we all know things have gotten very rough in terms of uncertainty, particularly for those in the manufacturing sector. We saw a decrease in the Ontario GDP, and we've seen the corresponding effects in employment. So you'll see that I put up there that in 2 years, Ontario's lost 20,000 manufacturing jobs, and the pressure has been escalating because of the trade war. The nice little graph from the Ontario government shows employment in blue, and then the rate of unemployment in percentages is the black line, and you'll see that pandemic spike. But then unfortunately, you'll see the growth again, and we're currently at 7.8% from April through September 2025. So why is this an employment trend? It's an employment trend and an employment issue from 2025 because a lot of clients are saying, look, we're facing a lot of economic uncertainty. We might even be losing work. And our labor costs are one of our big issues. What can we do about our labor and our employees to reduce that cost? And so this particular issue, I would say, is practically speaking, let's talk about a couple of those options that we've seen arising 2025 and being sort of highlighted this year. The first one is temporary layoffs. So those of you who were in your roles overseeing employees in the pandemic will remember all of the temporary layoff type of case law that came out of the pandemic, where all of a sudden there was new developments all the time. We've had a little bit of that again, to a lesser extent, but a little bit again because there's a whole spate of layoffs and the courts are saying new and interesting things about the layoffs all the time. So let's revise a little bit so we're all on the same page about temporary layoffs and the state of the law now at the end of 2025. You'll remember that the Ontario Employment Standards Act does allow for a temporary layoff. However, that layoff is going to constitute termination of your employee's employment automatically. So if you try to put them on layoff, they're automatically fired unless one of several things is true. So if their employment agreement or the collective agreement explicitly says you can put them on layoff, you're good. You can put them on layoff without firing them. Secondly, if they consent. So if the employee says, yes, I consent to being on layoff, you're also good. When you put them on layoff, that doesn't constitute termination. Or if the third one, if there's an implied agreement. So taking the pandemic aside, pandemic layoffs don't count. But if previously the employee's been on layoff multiple times and never said, hey, this terminates my employment, you're probably okay as well. So if one of those three situations is true, you can put your employee on temporary layoff and it doesn't terminate their employment. If they're not true, when you put the employee on layoff, it probably terminates their employment. Now, even if you can put the employee on temporary layoff, remember that you can only put them on layoff for so long before that becomes a termination of employment as well. In Ontario, the base is 13 weeks in any 20 consecutive weeks. However, that can go to a period of 35 weeks in any period of 52 weeks, as long as you can continue a substantive benefit, for example, or some other type of substantial pay during that period. So when we start talking about how are we reducing labor costs, if you're thinking of a layoff, I also want you to think about the work sharing program, particularly if you saw the last slide and you heard me talk about it and you said, oh, I can't lay off employees. Okay, let's talk about work sharing then. This is a very specific program in Canada that's aimed to help you avoid layoffs or terminations. The idea is that an employer and a group of employees, so all the employees in a certain group or division, agree that the entire group of those employees will work a temporarily reduced work week and they'll get a little bit of EI top up during that time. And that is meant to help employers avoid layoffs. We are currently having US special tariff measures in effect, which increases the scope and flexibility of this program. So it is a good idea to think about for anyone who might be experiencing downturns due to the trade war. Let's talk about how the work sharing program works, because I know it's a little complicated, so we put an example here. Take employee Bob. Employee Bob makes $25 an hour and normally works 5 days a week, 8 hours a day. So his normal pay is $1,000 a week. If the employer implements a work sharing program and all of the employees in Bob's unit agree to it, they're all going to go down to 4 days a week. Bob would then get $800 of pay from you, which constitutes 4 days worth of pay, and then he's going to get a top up from EI. Now, I always tell employers, don't guarantee the EI top up or the amount because you don't have any idea whether there are other circumstances with the employee that means they cannot access the EI top up. Okay, that's up to Canadian bureaucracy. That's not your decision or my decision how much they get. But assuming there are no other factors, in this example, Bob would probably get $110 from EI every week as well. So that means he's getting $910 a week for 4 days a week of work. Okay, so you'll see how that EI top up tries to mitigate some of the damages. It doesn't quite get Bob up to the full 1,000, but it's better than down to 4 days a week and no one is laid off. So, as I said, there are special measures for the Workshare program in effect from March 2025 to March 2026. And so, if the employer is experiencing a decline in business activity attributable to the threat or potential realization of US tariffs, you can access the expanded program. As you might imagine, this is heavily aimed at the manufacturing sector, but other of you may also fall into it. I'm not going to read you the entire chart, and this is still a summary. I won't say it's necessarily the world's easiest program to understand, but the important thing to note is that under the US tariff special measures, you can now work share for a much longer period. Okay, you'll see that the general program used to end at 26 weeks, and then you had to have a cooling off period before you could enter a new work share agreement. Now, if you fall under the US special measures, you can go for 76 weeks and there's no cooling off period. You can also do a greater reduction in employee workload. It used to be capped at 60%. You can now go higher than that if you need to. Remember, employees need to agree, so the chances of employees agreeing to more than 60% reduction is not great, but it's theoretically possible. It's also open to more employers. So if you looked into this a couple of years ago, let's say during the pandemic, and you said, wait, I don't qualify, well, I would look again. You just have to have been operating in Canada for more than 1 year. You can be a seasonal or cyclical employer now. If you're a not-for-profit or charity, under the regular program, you're not eligible. You might be eligible under the US tariff special measures. Double check the eligibility criteria, but you might be. And you don't need to prove the 10% decrease in 6 months in business that you used to have to. So, much more flexible, much broader. And if you are thinking you have some economic strain, I would encourage you to look into the work sharing program. Remember, the special measures are open until March 2026. They could be expanded, but as right now, ends March 2026. So let's say you've heard all of this and still not quite getting you through things. We understand it happens. Mass termination is something we want to flag for everyone because, again, it became a major issue in 2025 again. Remember, if you are terminating 50 or more employees in any rolling 4-week period, you have a mass termination on your hands. If you have a mass termination, everyone's floor, those employment standards minimums, increases. So the very minimum amount of notice and severance you get has to go up. It's really, really important you seek legal advice. It doesn't have to be me. Just go seek legal advice if you are laying off or firing anywhere close to the mass termination numbers. The reason for that is because there are notifications that have to be given, including to the government, and remember you have expanded notice. If you mess up the notification, the notice won't count. So the problem some employers found in 2025 was that they had a mass termination on their hands, they didn't do the notifications properly, that notice they gave didn't count, and they had to do it all over again. And if you have expanded notice entitlements for 50 or more employees, you can imagine that's a lot of money. Okay, so became a big issue in 2025 and one we like to flag for everyone. Please remember that magic number, 50 or more employees in a 4-week period. If you're getting anywhere close to it, I would say 35 or more, or you're even contemplating it, please seek legal advice. So again, some of the strategies we would encourage people to think about because of the US tariff and trade war economic uncertainty is, can you switch to working notice instead of pay in lieu thereof? Is that going to ease the burden on you a little bit? How are you timing your layoffs and terminations for exactly the point I just made? Can you make offers of reasonable alternative employment to try to avoid some of the liability of terminating employees? And of course, as I said, the Service Canada work sharing program. Next topic. So one of the other, and it's a bit of an abrupt switch, but one of the other big topics we saw in 2025 was AI. It's here, it's widespread, it's here to stay. Let's talk about using it in the workplace and the trends we've seen through 2025. One of the big ones is AI use in recruitment and selection. We understand why it happens. Going through a lot of resumes is time-consuming, difficult work, and so a lot of companies are turning to AI tools to help them recruit. The problem is that in 2025, we saw a bunch of issues regarding human rights in this ground, and we're seeing increasing human rights claims. What's happened is that, remember, AI tools are not actually smart thinking tools, right? They are trained on the data available to them. And that means that if you have biased data going in, you get biased results coming out. And so you saw the perpetuation. You might have seen some of the news about Amazon's secret AI tool that had a gender bias, for example. No one means for it to happen, but it can happen. So if you use AI in your selection, we generally recommend having what we call a human in the loop. That means spot checking, just doing an overview of things to make sure you are not getting yourself in hot water because the AI tool you're using is biased. There's also candidate privacy implications, of course. If you're feeding people's private information into an AI tool, some people have specific AI tools. We've had people just throwing resumes into ChatGPT, which we'd encourage you to think about again. Now, there's a note here. We're going to come back to this for my 2026 crystal ball issue. But remember that as of January 1st, 2026, you're going to have to notify candidates if AI is used in job screening, posting, and selection. And so that is partially going to draw the rise of more possible human rights complaints if people think that the AI tool you're using is biased. So that's why it's a trend right now, and it's going to become more of a trend because of this new rule in 2026. Employees are also using AI in the job. You know it, I know it, they know it. There are some good reasons to do so, for sure. But there's also some very poor effects coming out of it. If it is used improperly, we have seen significant risk to employers because they are depending on facts that don't exist or AI hallucinations, and it causes serious reputational risk. The problem is that you need to have a policy that guides AI use in the workplace. And you'll see that's my bottom line at the bottom of the slide there. Please, 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 employees are going to use AI. And if you want them to only be using AI in certain ways, or you have expectations for them to use AI and then check their facts, that should be in a policy. Because if you need to discipline or terminate because of it, you need to have clearly set out your expectations. You also get employees disclosing confidential business information because they'll, for example, put sales data into ChatGPT and say, can you summarize this for me? I understand the urge. It may make sense, but is it confidential information? You can also have non-compliance with your privacy obligations to your own clients. And then also AI is just getting trained off of your company data. So I said it, I think twice now, I'll say it once more. Employees will be using AI. Please put guidelines around it. I also see some employers using AI to monitor their own employees for productivity, for example. This can be a bit of an issue. You might recall that there is now in Ontario, and has been, I guess, for the last year or two, that requirement that you disclose electronic monitoring of employees in Ontario. If you are using AI, that has to be on there. If you are a unionized environment, remember that the arbitral case law, arbitrators have imposed quite strict employee privacy rights. And so you want to make sure you're not offside with those, and you might be, depending on your employee use for AI use for employee monitoring. We've also started seeing interesting things come up in discipline cases. So we have employees who are harassing others using deep fakes. We also have employees trying to pin the blame or create situations using AI. If the earlier slides weren't enough for you about investigations, this is your reminder to please investigate things thoroughly because you want to be able to say you did look into this image and this is the reason why you thought it was genuine or not, or at least you asked, rather than terminating someone based on an image that's because of AI, for example. So, another issue that you will all know and probably hate from 2025, return to office mandates. And if you were dealing with return to office mandates, I'm very sorry. If you weren't, I'm sure you saw all the headlines about them. Brief reminder, you have the right to determine the location of work unless the employment agreement or the collective agreement allows from work from home, either implicitly or explicitly. And by implicitly, I mean, if you've let Bob work from home for the last 5 years, you're going to have a really hard time arguing that it's a requirement of his contract that he work in the location where you're at. Okay, that is going to be a difficult issue. The other one, and the one I'm going to focus on today, is work from home accommodation requests. Because we saw return to office mandate problems for the last 5 years, but the big issue everyone's been raising with me this year is I have employees asking for an accommodation, usually a family status accommodation, and saying they should be working from home. First point, employees, remember, are not entitled to the preferred accommodation. They are entitled to the accommodation they need, not the accommodation they want. If an employee can be reasonably accommodated and they have a genuine need by something that is not work from home, then they're not necessarily entitled to work from home. A couple of tips we put together based on things that have arisen in 2025 about addressing these work from home family status requests, just in case you too have seen a sudden uptick in these. As I said, you want to verify that there is a genuine need, not just a preference to work from home. And the way you do that is by asking polite civil questions and requesting appropriate documentation. Okay, so you can't interrogate the employee about everything under the sun, but you can formulate some reasonable questions. You don't just have to accept it at face value when they say they need an accommodation that is work from home. Things that you might be asking about is the relationship between the employee and the family member to whom they have caregiving needs, whether there's any particular needs of the family member. There's going to be a difference between somebody who might have a child, let's say, who's a teenager, but has serious medical complications versus one who maybe is child who's a teenager, no medical complications. Okay, you might have a different context there, and you should investigate that. Why does that employee personally need to be doing the caregiving? And again, you want to be careful about how you ask those questions, but if they have other family members, if they have a partner, are there, do they have siblings that are going to help them take care of their parents? Those are all questions that you want to gently probe at. And this is particularly true. What efforts have been made to find alternative care? So are they on daycare wait lists? Have they investigated home care options for elderly care? Are there family or community supports? Have they contacted in with the social worker at the hospital where their mother has been, for example, to see if there's other options that they can take advantage of and that can be of assistance to them? And so you do sometimes find yourself doing a little bit of research before you go into these meetings, so you can say, what about this? What about this? And the point is to engage through that collaborative process of, if there is a genuine need, what does this look like? And then what can we do about it? Okay. Again, you don't need to provide a perfect accommodation. Some employees will say things like, well, I'd prefer to work from home. And I understand that. We can understand that. We can have sympathy for that. We can understand it would be easier and better for them. It doesn't mean they're necessarily entitled to it, though, under the law. And you might consider such things as, can you do flexible work hours? So the employee's sometimes going to come in a little early or sometimes going to stay a little late, but they're always going to be there between 10 and 3. Are there going to be some flexibility on in-office days so that if they really can't find elder care on Tuesday and that's the day the home nurse doesn't come, they can work from home on Tuesday, even though normally they'd have to work from home only on Wednesdays, right? If you've got multiple work sites, can they move to a different location that's maybe closer, helps with drop off and pickup of their child? And I always encourage people, let's think about short-term accommodation. So if we think there's a genuine need, let's do a short-term accommodation while we gather more evidence and more information. And then you're being very reasonable, but you're also not committing to a permanent accommodation right off the bat. And number 4 there you'll see is, once an accommodation is in place, please remember to check in. Children get older, care situations change, and sometimes I have an employer who says, oh, I let Bob work from home for the last 3 years because of an accommodation, and we find out that the need really only existed for a year and a half. We also had some new statutory leaves come up in 2025, and I do this one right on the back of the family status accommodation because it's important and not enough people know about this leave. Long-term illness leave came in June 2025 in Ontario, and it is a unpaid but job-protected leave, so similar to maternity leave, that can last up to 27 weeks in any 52-week period. To be eligible for the leave, all the employee has to do, and I really do mean this is it, they just have to bring you a certificate from a qualified health practitioner saying that the employee has a serious medical condition and saying they will not be able to work for this period. And that period has to be no more than 27 weeks in a 52-week period. That certificate's all they need for the leave. And this is important because most of you, being, accomplished human rights people or human resources people, forgive me, or owners of business or involved in businesses and management will say, well, normally when somebody says they have a medical need, we ask for more information. You're exactly right about that. But because this new leave only requires that certificate, you don't necessarily get to ask for more information if they provide that certificate. The certificate does have to say serious medical condition. If it just says the name of the condition or describes the condition, that's not good enough though, okay? And it does have to be a qualified healthcare practitioner. I had somebody bring one in from their chiropractor. That's not on the list of qualified healthcare practitioners. It's generally things like a physician, nurse, registered nurse, psychiatrist, or psychologist, for example. One of the tricky things about this too is that the employee doesn't necessarily have to provide you the certificate before they start taking the leave, but they do have to provide the certificate to substantiate the leave, okay? So we've all been in that situation where the employee says, gotta go, I've got a medical emergency, and you say, great, get me the medical in like a week or two. You might get the certificate, okay? And you need to be aware that that is a job-protected leave. Effective November 27th, 2025, so pretty much fresh and hot off the press, there's also this other job-seeking leave that came into effect. If you are doing a mass termination, the employee can take 3 unpaid days during that notice period if they are one of those employees being terminated and if they're engaging in activities related to job seeking, such as interviews, training, anything like that. You can ask for some proof that they are doing these things, though, so make sure you do so. I am not going to talk about this one in depth because I assume most of you are not digital platforms with workers. And by digital platforms, I really do mean it's the provision of rideshare, delivery, or courier services by a worker who's offered work assignments through a digital platform. Okay, so Lyft, for example. If you are a digital platform, you will want to look at this because there's a bunch of requirements. But again, as I said, I would normally skip it here, assuming it's not applicable to most of you. So that's my, hey, here's the big things, topics, trends, and issues that arose in 2025 that I'd want to highlight for you. There's always more. I could talk about this issue for ages, but I think those are the big ones that, as I said, were keeping employers up at night. But if I gaze into my crystal ball, what do I see for 2026? We're going to see a continuation of a lot of these issues. You heard me talk about AI. That's alive and well. It's going to keep going. We're going to continue to see those family status, work from home requests. We know that's ongoing. But there's also a couple of issues that we know are coming, but haven't come into force yet. So please remember, January 1st, 2026, job posting rules come into effect. This applies if you have 25 or more employees in Ontario and you are posting a publicly available job posting. So not an internal job posting, but anything available to the public. If you are doing that, there's a couple of requirements. First, you have to provide the expected compensation. It can be a range of compensation, but that range can't be more than $50,000. If you expect the job to pay more than $200,000, you don't need to put the range down. You have to disclose 2 things. First, whether AI is used to screen, assess, or select applicants, as we talked about, so that has to be on that job posting. And then secondly, you have to disclose whether there's actually an existing vacancy that you're posting for. And by that, what we mean is there a genuine empty job that you're going to slot somebody into, or are you creating a pool of candidates for potential vacancies? That has to be identified on the job posting. You also have to inform candidates or any interviewed applicants within 45 days of their last interview about whether or not a hiring decision has been made. It's that sort of no ghosting people you've interviewed clause. The last one, but very important, is you cannot put on the job ad that you require Canadian experience. You can state that there is credentials that are required to do this job, and that might include things like licensing in Ontario. Okay, so for a regulated profession, you could say you have to be credentialed in Ontario. You can't require Canadian experience, however. So, what would I like you to do to address this? I'd like you to make sure that you've reviewed your job posting content to ensure compliance. Make sure your hiring personnel are aware of this coming into effect in January 1st, 2026. And then please ensure you keep records of the compliance with this. So especially that like letting interviewees know within 45 days, just keep records of it. So if you ever get audited, you don't have the headache on your hands of saying, yes, I did that, and then you have no records. Okay. We've all been there. Employment standards is going to look for those records. Second thing I see coming into 2026, this is just the minimum wage across Canada for 2025. We don't know for sure for most of these provinces whether there'll be any changes, but there very well might be. And so we always encourage employers to keep an eye on it. We do know, for example, that PEI is going to increase their minimum wage as of April 1st, 2026 to $17 an hour if you're a cross-Canada employer. And we may see others follow along, but please always remember to check your minimum wage and make sure you're in compliance with that. We know there's a new statutory leave coming in 2026. It's the placement of a child leave. It's just not in force yet, but it will be in force some point 2026. And this allows for 16 weeks of leave for the placement of a child into the employee's custody, care, and control for the first time for the purposes of adoption, or the arrival of a child into the employee's care when the person who gave birth to the child is a surrogate. The reason I raise this is because I don't expect you to remember the details. I just want in the back of your head in 2026, if somebody's got a surrogate or somebody's adopting a child, you want to have that little flag in the back of your mind go, oh, didn't Allison say there was something like that? And then you can go Google it, you'll find the leave, you'll be fine. Okay. But we know it's coming into force in 2026. We just don't know when. Less pleasantly, increased fines. This has been a trend and it's going to continue. Okay. This year with the Working for Workers 6 Act, you might have seen for the Occupational Health and Safety Act, if you are found guilty of a second or subsequent OSHA offense that results in the death or a serious injury of a worker in a 2-year period, the minimum fine is a mind-blowing $500,000. That's the minimum fine. Okay. This trend's going to continue in terms of new and higher penalties. Working for Workers 7 Act just came into force in November, and we know that there's an administrative penalty scheme coming in where the inspector is going to have the ability to impose an administrative penalty if they find a person has contravened or failed to comply with OSHA regulations. We don't know the amounts. Okay, that's going to be set by a regulation that we have not seen yet. We also know, because this is now in force, that under the Workplace Safety and Insurance Act, there's also an administrative penalty scheme for employers that make false or misleading statements regarding a person's claim for benefits. We know that if the employer does not meet the requirement to keep accurate records or does not produce those records to the WSIB when asked, there's always going to be an administrative penalty as well. Don't have case law yet on this, obviously, because it's brand new, but going into 2026, we expect to see more of this. Remember, the same act, which came into effect in November, also increased the max penalty of $750,000 under WSIA if the employer is convicted of 2 counts of the same offense in the same proceeding. Again, we're saying it's looking into 2026 because it's not here quite yet. We haven't actually seen it in effect, but these are the things we know are coming and we anticipate seeing in the new year. On that maybe cheery, maybe less cheery note, I will say one positive thing we are seeing is increased labor mobility. If you are having problems getting regulated professions into your workplace, this may be good news for you. Effective January 1st, 2026, you can bring regulated professionals into Ontario much easier. So what will happen is that they apply for what's called a deemed certification. and they'll get it within 10 days, which is really fast. And so within 10 days, they'll be able to work in Ontario if they're licensed in, let's say, Alberta. They get deemed to be certified for a single, and it is a single, 6-month period. During that period, they have to do whatever they have to do to get certified in Ontario. But for those 6 months, they're just deemed certified. This is going to cover most regulated professions outside of healthcare. So if you're looking for skilled trades, if you're looking for accountants, engineers, architects, early childhood educators, there's actually a very long list. I would encourage you to look at this because this might help you out. And Ontario's signed reciprocal agreements with 10 provinces and territories, so we might see a lot more increased labor mobility. And with that, I'm going to turn to some questions. So if you've got questions, please do put them in the Q&A. If you've put them in the chat, I will tell you I cannot see them. And so the Q&A box is where you want to be. So I am seeing a couple of questions about the 45-day notification process, presumably for employees that you have interviewed. And so the question says, for the 45-day notification, I have read that preliminary pre-screens are not included. Is this correct? Good question, Rebecca. The answer is because this is brand new legislation, that's probably true, but it depends what your pre-screen constitutes. If it could constitute an interview, then it is going to be an issue. If you're just pre-screening resumes, probably doesn't count, of course, right? And I'm assuming you're talking about something in the middle where you're picking up the phone. And so I would say you'd want to look at the exact nature of that and how close it is to an interview. I tend to say err on the side of caution if you can, but I realize that's not always possible. If you have a two-stage interview process, the question goes on, and you are not moving someone from the first interview to the second, is it sufficient to let them know they have not moved forward? Yes. And in terms of that, you would tell them that a hiring decision has been made not to move them forward, right? Like you can just put that and that should be good enough. Okay. Couple other questions. Does the compensation transparency apply to overseas hiring as well? And if it is over $50,000? Okay, so I think the anonymous attendee is asking about the job posting requirements and whether that applies to overseas hiring. The thing is, if it's a publicly available posting, it's technically covered. Now, is the Ontario government going to try to prosecute you for something which is posted in only Vietnam? They have to find it first, but realistically, you're an Ontario company or you're operating in Ontario, you are bound by Ontario law. Okay, so again, what I say with a lot of these ones that might seem like very minor issues is why invite a finding that you are in non-compliance if you can just make a small change and then avoid that risk entirely? No one wants to invite employment standards into their workplace. No one wants an audit of their workplace by employment standards because they ask a lot of questions. And so what I would strongly suggest is if you can, do put those notifications on, just make sure that information's there, and then you really don't have to worry about it. In terms of when you say it is over $50,000, $50,000 is the range of compensation you can give. So let's say you were going to say, this job is open, it's going to pay somewhere between $50,000 and $100,000, or $50,000 and $75,000. The actual limit is $200,000. It's when the job is expected to pay more than $200,000 that you don't have to put the compensation on. $50,000 is just the maximum range you can put. So you can have a range of 10, 20, 30, 40, 50. You cannot put a pay range that is $60,000. Okay. And I hope that makes some sense. If there are any other questions, don't hesitate to let me know. I think otherwise, those are the only two questions I see at this point in time. And if that's the case, I'm certainly hoping, I cannot talk anymore after a seminar, certainly happy to turn this back over to Angelica.